They are elected by you. I am elected by you. I am constrained as they are constrained by a system that our founders put in place.
The founders separated power because they knew it was the best way to protect our citizens.
They didn't want one person, one man to have all the power like a king.
We show by our work that free people can govern themselves.
You can't pay lip service to the Constitution without obeying it.
Keep your eye on the ball. Structure is destiny.
This is Necessary and Proper, the podcast of the Federalist Society's Article 1 initiative. All views expressed on this podcast do not necessarily reflect those of the Federalist Society. Welcome again to Necessary and Proper. This is Nate Kazmarek, and I'm excited to have with me Adam White, who is a research fellow at the Hoover Institution. He's also director of the Center for the Study of the Administrative State at George Mason University's Antonin Scalia Law School. That's a mouthful.
It is.
And he also teaches administrative law there. Adam, how are you today?
Well, good, thanks. Thanks for having me.
Very good. When did you join Hoover?
Well, I joined the Hoover Institution in late 2015. I'd been practicing law at the time for Boyd & Gray and Associates, and had practiced years before that at a larger firm. And joined the Hoover Institution in the fall of 2015, first as an adjunct fellow and now as a research fellow. Okay, great. And I think you previously clerked for Judge David Santel on the U.S. Court of Appeals for the D.C. Circuit. Is that right? I did. He's a great judge.
Very good. And as I mentioned, you've now moved over to be director for the Center for Administrative State at George Mason University. How long ago did that happen?
That started this summer. That's right. I'm now both at Hoover and at George Mason. So I call myself bicoastal. I'm on both sides of the Potomac now. And I took that over as Naomi Rao, a professor at George Mason and the founder of the center, was nominated and appointed by President Trump to be what's often called the regulatory czar, the head of the White House Office of Information and Regulatory Affairs. She had founded the Center for the Study of the Administrative State a couple of years earlier. She's been its executive director ever since, and now I've succeeded her. Okay, and I'm sorry, how long ago did Naomi Rao found it? About 2 years ago. 2 years ago. And can you tell us more about the center, why it's needed, and what sort of issues it tackles? Well, I think the best explanation for why it's needed is to just take a step back and look at the conversation we're having right now about the administrative state in all three branches of government and the public. In Congress, the executive branch, the courts, with very interesting opinions coming from Chief Justice Roberts, Justice Thomas, and others. And in the states, there's been this ongoing conversation about the nature of the administrative state and the need for regulatory reform for years now. And the center, I think, is a one-of-a-kind it's a one-of-a-kind place in that conversation. It's a reform-minded research facility that is focused on bringing scholars together of all ideological approaches to have conversations about the emerging issues in administrative law, little things like ways that financial regulation or environmental regulation works, to bigger questions about due process and judicial deference and so on. And so our center, first and foremost, conducts a cycle of private workshops and then public conferences on specific issues. Like I said, environmental or financial regulation we've done, judicial deference we've done. It begins with a few authors drafting papers that are presented at a private workshop with academics and practitioners. The papers are polished up a little bit, and then we have a public conference where the authors and other panelists can discuss and debate the issues. And we do a few other things in addition to that. We do sort of one-off events. We did an event on Capitol Hill when Naomi was still running the center. In late September, we'll have a panel discussion co-sponsored with the Hoover Institution, previewing upcoming Supreme Court and D.C. Circuit cases. And we'll have other events like that as well. But like I said, the center's main purpose is to be a home for thoughtful discussion and research of these really challenging questions that are arising in our time.
Oh, very good. And when it comes to the administrative state, the subject matter you're talking about at the center doesn't just focus on one branch or another. It's the fact that all three of them are problematic in this regard.
That's right. If you're the Article 1 project, I guess we're the Article 1, 2, and 3 project. We focus on the relationship between the administrative agencies and all three branches, right? Of course, all agencies get their powers from Congress, and there's interesting questions about how or why Congress vests certain powers in the agencies. Then there's the separate questions of the president's oversight of those agencies. And then, of course, in issues like Chevron deference and so on, there's questions about the judicial branch's relationship to these agencies.
Well, very good. We're looking forward. Congratulations on your new
Thank
post
you.
there, and we're looking forward to continued good work out of that center. I thought before we get more specifically to Congress, we would, address your role at Hoover, and I wondered if you might tell us a little bit more about your position as a research fellow, specifically, for those who aren't familiar with that type of position. What does that position entail, and what sort of work do you do?
Well, even before I joined the Hoover Institution, I'd been writing a lot on the courts and the Constitution and regulation for a variety of publications, and I'd been an adjunct fellow at the Manhattan Institute. When I joined the Hoover Institution, I sort of continued that work just full-time. Mm-hmm. So I do a few things. First and foremost, I research and write articles, scholarly papers, and also articles for the Weekly Standard and reviews for the Wall Street Journal and other places on sometimes very broad issues. Or I wrote a piece last year on Federalist 78 on the courts, so very broad. But sometimes it's very narrow. How does some very specific aspect of regulation work? And the Hoover Institution gives me the opportunity to really think broadly and deeply about these issues and to write them in a variety of formats in the best way to sort of bring these ideas and these issues to the public. Now, in addition to my writing, I do a lot of public speaking now. The Federalist Society has been a very, very generous host to me in that respect. Mm-hmm. But also, and this is something I really, really enjoy at the Hoover Institution, is they've given me an opportunity to convene discussions, either private meetings or public meetings, where great ideas can be debated and discussed. I have a discussion series at the Hoover Institution called everything's a long title. First, the Center for the Study of the Administrative State. Right. Now this, Opening Arguments, Conversations on American Constitutionalism, where we bring in speakers to reflect on constitutionalism in its broadest and best sense, not just Supreme Court cases, although of course they're important, but just broader questions of who we are and how we govern ourselves. And that series the speakers have included everybody from Hadley Arkes, the political philosopher, to Senator Mike Lee in a forerunner to the series. We've had Randy Barnett, we've had Yuval Levin, Rabbi Meir Soloveitchik, and a number of really interesting speakers who have come in and offered their perspectives on America and how it governs itself. And that's one of the really, really enjoyable parts of my work.
And I assume, given your new role at the center, you've always been focused in on the administrative state. Is that a particular passion of yours? Is that something you've been researching and interested in for many years?
Well, it is. That was basically my career before I left practice to join the Hoover Institution. I got to say, I had no interest really in this at all in law school. I mean, it was vaguely interesting, but when I graduated from law school, I assumed I was going to be an antitrust lawyer. Mm-hmm. But I had the amazing good fortune of getting a clerkship with Judge David Sentel on the D.C. Circuit. Mm-hmm. And so I had a steady diet of regulatory cases, but also with Judge Sentel, a really wonderful education on constitutional structure and the role of the administrative agencies for good and sometimes for ill in that constitutional structure. And so I went on to practice for about 6 years at a big law firm working on energy regulation. And so I had a very up-close look at the agencies, both in the federal and state levels. And then after that, I spent another 5 years working with Boyd and Gray, who's one of the really he's one of the most significant administrative law lawyers of our time. I mean, he was present for the creation in the Reagan administration, the creation of the modern White House oversight framework. Mm-hmm. He played a leading role in framing that up, and he's played a leading role in administrative law ever since. And so even in just my daily legal practice, I had an opportunity to really do interesting things and see interesting issues in the administrative state, and it just kind of grew from there. It's interesting. In some ways, the questions we ask about the administrative state are kind of the flip side of the same coin of the questions we ask about the courts. The courts and the agencies both are these parts of government that are not directly elected, and we vest immense power in them, in the judges and in the agency officials, primarily because of their expertise. And so these questions that we ask ourselves as a country, going back to the very beginning of our constitutional republic, where the first Congress had to create the first agencies and vest power in them, we've asked ourselves over and over again, what issues do we commit to these expert bodies, the agencies and the courts, and how and why? And the questions just keep repeating over time. It's a never-ending debate, and to me, a very fascinating one.
Well, agreed. And let's turn just over to Congress and their role in the administrative state. We acknowledged earlier that all branches have some role to play, but it seems to me, based on things I've read of yours, that your feeling is that Congress is probably most at fault in this area. And you've talked about, is it a lack of ambition? Is it they don't want to be accountable? Why does Congress give away so much of its power to these unelected bureaucrats?
Well, that's right. One of the sort of assumptions that the Founding Fathers made, and we see it in things like Federalist 51, about Congress was that Congress would be the most ambitious and powerful branch. James Madison said it would be this insatiable vortex, just drawing everything into its grasp. And the lesson of the last century now has actually been the reverse. It's been one of Congress handing power away, often for very, very good reasons. I mean, there's no shortage of reasons why agencies are important and play an important role in terms of technical expertise, in terms of Congress not having the time or resources or expertise to pursue some issues. There's perfectly good reasons why you would have agencies, but the trend for the last century has been Congress over and over again vesting power in immensely broad terms to these agencies and structuring these agencies with ever less accountability to both the president and the Congress. So it begins with Congress. The agencies have no power to act, the old saying goes, until Congress vests power in it. But then the question is, why does Congress hand so much power away? Again, my predecessor, Naomi Rao, wrote very interesting things on this while she was still at Mason, writing about how sometimes it's in individual congressman's own interests to hand that power away. But the line I return to over and over again is a line from the law professor John Hart Ely, famously wrote this book, Democracy and Distrust. In one of his later books on war, on the Vietnam War, he began with a reflection on why Congress had handed so much of its war power to the executive branch. And Ely said that this transition of power from the legislature to the executive, it's often styled as a usurpation of the president taking power from the agencies. Mm-hmm. But actually, Ely says, it's very different than that. It was Congress giving its power away because Congress was frightened of being held accountable for these issues.
Mm-hmm. And it seems to me that that these elected officials, I mean, it's not like they're not concerned with their communities, the communities that elected them, or the individual issues that they're passionate about. But it seems to me also that they just no longer strive for defending the institution and its power, right? It seems to be the trend that they just are avoiding that space and leaving it to the agencies. So.
I think that's right. I want to be clear here. When Madison and the framers talked about ambition, they weren't saying that ambition was good. They were saying ambition was a vice or an evil, but in some ways a necessary or productive evil, right? For our system to work, we count on all three branches, especially the executive branch and legislative branch, to be ambitious enough to check and balance the other's ambition. And when Congress becomes less ambitious, it allows the president, the agencies, and the courts to disproportionately fill that gap. Meanwhile, Congress has found that it can achieve, individual congressmen can achieve their political aims or political ends by basically serving as ombudsmen for the administrative state. Having past Congresses having vested this power in the agencies, the current Congresses are more content to spend times in hearings beating up on agency officials, both from the right and the left, having a good show and criticizing the agencies, but never really returning to the question of how should we reform the statutes that vest that immense power in the first place. And I don't want to overstate things. I understand that achieving legislative reform is very difficult, and for good reason. But at risk of being, I hope I'm not being unfair to Congress when I say this, and I say it all the time, they really need to think more and work harder on the legislative side of things than on the oversight side of things.
I see. And how is this, this progression work to the detriment of individual Americans? I mean, why is this a problem?
Sure. Well, again, we have checks and balances not as an end in and of themselves, but in service of liberty. Right? That was the real genius of the framers, was that checks and balances and structural safeguards in our Constitution would be the best protector of liberty. The framers knew that when you combined, this is the old line from Montesquieu, when you combined executive, legislative, and judicial power in a single set of hands, that's where tyranny begins. I don't want to say that the agencies are tyrannical, but they certainly do have immense power of a legislative, executive, and judicial sort now in the agencies in terms of the powers that are vested in them and the procedures by which they can use those powers. And so when law is primarily made through what we call notice and comment rulemaking or guidance documents or things like that, instead of the messy friction of checks and balances in Congress, you see more laws being created more swiftly with less deliberation, less meaningful deliberation, less compromise. It becomes a form of constant unilateral rulemaking, subject to the constant threat of unilateral changes to those rules. And so you ask, what does that mean for people on Main Street, people working on business, in businesses, people in their daily lives when they run into things like the Affordable Care Act? It means that nobody really knows what the law is anymore. And even if you can invest enough time into finding out what the law is today, there's no real assurance that the law will be that tomorrow or the next day. That's no way to run a country, and it's no way to run a Republican country. And I mean that in the lower R sense, this idea of the people having the ultimate sovereignty over their governmental officials.
And obviously it's a heavy lift over a broad range of issues, but how do we convince the individual members of Congress that convince them that we need to adhere more closely to the Constitution? They need to pull this power back.
Well, on the first question about how to really put this on their radar, I think we actually saw a lot of that in the last few years. In the last couple of years of the Obama administration, we saw things like the Clean Power Plan, which would have radically changed the way that our energy markets and everything relying on those energy markets were to be governed in the United States. We had the Affordable Care Act, obviously, and the rules implementing it. We had the net neutrality rules coming out of the FCC and the Waters of the United States rules governing private lands and the use of private lands. And those four sets of rulemakings, I think, were a real wake-up call to members on Capitol Hill about how immense the powers of these agencies are and how much they could do with these old statutes like the Communications Act of 1934, how much the regulators could do with those statutes. I think those were a real wake-up call, especially when the administration kept changing a lot of these rules on the fly as they were being implemented. And so I don't think that it's a partisan issue. I don't think that the wake-up call was Republicans in Congress watching a Democratic president make policy. Because if that's all it would take for a wake-up call, then there would have been a wake-up call in 1993, all the way through the Clinton years. But something fundamentally changed, I think, in the magnitude and the process by which the executive branch agencies were making rules in the last few years. And that's why you suddenly saw real calls for reform on Capitol Hill with things like the REINS Act and the Regulatory Accountability Act. And the question was, would that legislative energy be sustained into the next administration, especially if it were a Republican administration? I think it's too soon to tell, and we can talk about this at some point.
Sure.
I think it's too soon to tell, but it'll be interesting in years 2 and 3 and 4 of President Trump's first term, what sort of legislative energy there is for meaningful reform.
Sure, this is a great time to transition to that. Let's talk a little bit about the REINS Act. It's the regulations from the Executive in Need of Scrutiny Act. It's been passed by the House. What does that proposal endeavor to do?
Sure. Well, one of the problems we've already discussed is this problem of Congress just delegating immensely broad powers to the agencies in things like the Communications Act or the Clean Air Act or any of these statutes. Now, instead of picking these statutes one by one and reforming them, what the REINS Act tries to do is to go across the board, across all statutes, and pull back from the agencies the power to make the most consequential rules, the costliest, most burdensome rules. For the most expensive rules, the agencies would not just be able to announce them unilaterally like they currently do. Instead, they'd be sent to Capitol Hill, where Congress would have to vote up or down on these costly rulemaking procedures. And so the REINS Act, in a nutshell, is a pulling back of that delegation of legislative authority and requiring Congress to actually vote on the costliest regulations.
And that, we're talking about rules that would have an impact of $100 million or more, I believe, right? And do you know the status of it I think it's in the Senate now, right?
It's passed the House, I think, and we're waiting for action in the Senate.
Okay.
And by the way, we've seen that before. I mean, this passed the House over and over again.
Right.
And it'll be interesting to see what happens in the Senate this time.
Well, and it'll be interesting to see, given the busy legislative schedule and how many days there are left even in this year when they come back from recess, how much room and space there'll be for these regulatory measures.
Well, that's right. And I think, before we talk about any other bills, I think it's very important to make that clear that there's only so many hours in a legislative day or a legislative year, only so many hours in any day or year. And so when the administration and Congress are already focused first on health care reform and then on tax reform, and there's also the budget issue, and then there's all these appointments that need to be confirmed by the Senate, more and more appointments as officers who have already been confirmed are now already being replaced. That takes up so much time that it's really a question of when, if ever, the Senate will be able to get around to some of these things.
Well, let's talk about a couple other examples. I think you mentioned the RAA, the Regulatory Accountability Act.
That's right.
And that involves?
That's a big set of procedural reforms. Instead of, where the REINS Act goes to the delegation of power to the agencies, this goes to the procedures by which the agencies could exercise the powers they've already been delegated. Now, for 70 years, this has primarily been governed by the Administrative Procedure Act of 1946, which has really never been meaningfully updated by Congress. And over the years, the more rigorous parts of the APA have basically fallen into disuse. And what I mean by that is what we call formal rulemaking, almost trial-type procedures for the costliest of rules. The Supreme Court made clear in the 1970s that that type of rulemaking isn't mandatory, that the agencies have pretty broad discretion to just go through this normal notice and comment rulemaking, where an agency notifies the public that it's going to make a rule, it accepts comments, it sort of vaguely looks at those comments and responds to them, and then it just goes ahead and does whatever it wants to do anyway.
Well, I'm sure it pays attention when if the comments are largely in their favor. Right?
Well, that's right. That's very true. What the Regulatory Accountability Act would do would be to amend the APA to put real procedural teeth back into it. So again, for the costliest of rules, you would have multiple rounds of notice and comment and formalized trial-type procedures in which the public could really challenge the experts presented by the agency and to challenge the substance of what the experts have put into the rule. And so it would make the rulemaking process significantly more stringent, more challenging for the agencies. Now there's drawbacks to that which we can get to, namely agencies might start to think that they ought to just not do rules at all and instead make their policy through even less formalized means. So that's something that we need to keep in mind. But on the whole, it would really put teeth back into both the process and then put teeth into judicial review and judicial review of cost-benefit analysis. And so in short, the Regulatory Accountability Act is a big suite of reforms going to agency process and judicial review.
And have there been over the years many attempts by Congress to to change the APA?
There's been proposals over the years, including all through the Reagan years, where Senator Bumpers from Arkansas and Democrats were really focused on this as well. And in the 1990s, both with people in Congress and the Clinton administration thinking about how to modernize government. I mean, this has been a debate that's gone on almost constantly since 1946. It just has never really borne real meaningful fruit. Again, this is one that's passed the House. It's passed the House repeatedly.
Right.
It's now been introduced in the Senate. A version of it's been introduced in the Senate by a bipartisan group of senators, including Senator Heidi Heitkamp and Senator Joe Manchin from the Democrats. This is I really like this bill, actually.
Right.
In some ways, I like it more than the REINS Act, although I think they're both very good. And I'm hopeful that this will get some progress in the Senate, although I don't want to sound naively hopeful. It's still going to be a real challenge.
Sure. And I know there's been proposed bills with regard to Chevron deference. I think one is the Separation of Powers Restoration Act. Can you describe a little bit about that bill or bills like it, where the Congress is trying to address the Chevron doctrine?
Yeah, this is actually kind of amazing if you step back and think about it. Chevron deference is something that judges and lawyers and law professors have been debating for a long time, but it's not the kind of thing that makes its way into ordinary political discourse.
Right.
Again, and this is Chevron deference, the amount of deference that federal courts give to federal agencies interpreting ambiguous statutes. The bottom line is that courts are supposed to defer to an agency's reasonable interpretation of an ambiguous statute, more or less. And again, in recent years, this has come under withering scrutiny, especially from scholars like Philip Hamburger, Justice Thomas, and others who say that anytime a court is giving deference of any sort to an agency, it's really an abdication of judicial duty. It's not, as Hamburger says, it's not Chevron deference, it's Chevron bias. And so there's been this sustained call in the courts to reform or trim away Chevron deference. Incidentally, you've seen this on both sides of the aisle. Justice Breyer was just as eager as others, let's say Chief Justice Roberts, to make exceptions to Chevron deference. And now you have a bill by which Congress would tell the agencies, we do not want you to defer. We want you to interpret these laws de novo. Now, I do just want to say that on Chevron, I'm somewhat agnostic. Chevron deference, I think it's now clear, has real problems and imposes real costs on society in terms of self-governance. At the same time, though, it's possible that the only thing worse than Chevron is the absence of Chevron deference, because Chevron deference arose for a reason. It arose in the 1970s and into the 80s when the case finally happened in reaction to federal judges really micromanaging policy reform in federal agencies. And Chevron deference was an attempt to create space within these very capacious statutes for policymakers accountable to the president to have real policy discretion. And I do worry that now that we've seen the excesses of Chevron deference, we'll see it torn out root and branch, and we will quickly see why we had Chevron in the first place. Now, if I know I'm filibustering here, but if I could just offer one suggestion.
Please go ahead.
One proposal I've made in a few places, including in a book or booklet I co-authored with Orrin Cass and Kevin Kosar at National Affairs. I think we did a Federal Society podcast on this, actually.
Yes.
I argue that we should sort of knit the Chevron and procedural issues together. And here's what I mean by that. I said a few minutes ago that the problem with imposing too many burdens on an agency, too many procedural burdens, is the agency just won't go through the process at all. It won't make rules. It'll just issue more guidance documents. It'll do more things through adjudication, but it'll just evade the rulemaking process altogether. And so my suggestion is let's use Chevron deference as the carrot to get the agencies to go through that process. And what I mean is, instead of getting rid of Chevron deference altogether, Congress, I think, should consider getting rid of it for interpretations that arise out of anything but rulemakings. If an agency has legal interpretations in an adjudication or a guidance document, then those wouldn't get Chevron deference. But if the agency goes through the full rulemaking process, they do get Chevron deference. That way an agency would have a choice at the beginning of the process. Either they can sort of skip the rigors of formal rulemaking and do it the easy way, knowing that they're going to get much more judicial scrutiny on the back end of the process, or they could invest, real effort in the hard work of a formal rulemaking process up front, knowing that their reward at the end is that you'll get some more judicial deference. Now, as it happens, those sorts of instincts are already present in some of the Supreme Court cases. But more importantly, when you go back and look in the 1930s and 1940s, when Congress was thinking about what procedures to impose on agencies in the first place, they were thinking a lot about this relationship between process and judicial review. Today we'd use a term like pay me now or pay me later. Back then they used similar terms. This is one funny report. It's, funny to lawyers, not funny to normal people. But in the 1930s, one of these studies of the agencies, they classified these sort of safeguards of democracy in the regulatory process as either prenatal or postnatal safeguards. Prenatal safeguards like more notice and comment rulemaking, more process, and the postnatal safeguards were things like judicial review. And I think it's time that we return to thinking about these two issues, the process and judicial review, in a cohesive whole and not stovepipe them into separate discussions, which is mostly what happens now.
So are you suggesting that Congress would codify this, or is this a solution that the courts would bring about? How do we come to that?
Well, the courts do it a little.
Solution.
The courts do it a little bit under some Supreme Court cases called Meade and Harris. What I would propose, if Congress wants to do it, is to do this. Right now, in the Separation of Powers Restoration Act, Congress tries to get rid of Chevron deference by saying courts shall review interpretations de novo.
Right.
All they would need to do, if they wanted to adopt my approach, would be to change that language to say courts shall review legal interpretations arising from, and you can sort of cross-reference to the parts of the APA for adjudications or guidance or whatever.
Sure.
Review those de novo and review then formal rulemaking or notice and comment rulemaking with Chevron deference.
I see.
Or you don't have to use the magic word Chevron deference. But all I'm saying is take the existing language for the Separation of Powers Restoration Act and just tweak it to focus only on these things other than the rulemaking process. And again, I think that actually creates the incentives to get the agencies to do the right thing in the first place, which again, I think is the approach that I think in a way it sort of echoes the framers' approach in framing the Constitution in the first place. It's not that we write laws and assume government will do the right thing, right? It's that we write laws that create the hydraulic forces that push the agencies to do the right thing, or the gravitational forces that pull the agencies in the right way. And I think using Chevron deference as an incentive would have that same hydraulic or gravitational effect.
Oh, it's very interesting. Thank you very much for sharing all that.
Well, thanks for letting me filibuster.
Not at all. In terms of other reform proposals for the administrative state, I know just from looking at it briefly on my own, there's a proposal, the Agency Accountability Act, which would require agencies to turn over the monies and fees that they collect to the Treasury as opposed to keeping it for themselves. Are there other proposals or any comments you'd like to make about that one that you'd like to share with us?
Well, I'd say there's a number of issues that have arisen in sort of these smaller, more specific ways that people see as very problematic. The one you've identified is agencies having this ability to claim massive sums of money through fines, and rather than handing them to the Treasury, just holding on to them like a slush fund so that the agency can spend however it wants. I think this is a profoundly dangerous trend. James Madison said that the power of the purse would be Congress as the people's most effectual tool for restraining the other parts of government. And it was crucial to have that in Congress. These slush funds that the agencies have created are really I think a flagrant violation of the principle that Congress needs to be in control of the money. And it also creates a real tactical advantage for the agencies where they can then spend on whatever priorities they like. They can reward favored constituencies and so on. I think it's a dangerous tool in the hands of the agencies. So that's one. There's other smaller reforms. One goes to this is a very technical issue, but it goes to the question of whether agencies should be allowed to enforce their decisions before judicial review. Right? Mm-hmm. In administrative law, most of the time, once an agency has made its decision, it can begin to implement that action while the courts are reviewing it. And so sometimes you actually have scenarios where the agency will force an entire industry into compliance before the Supreme Court or the courts of appeals have had an opportunity to decide the issue. This came up a couple years ago in an EPA case called Michigan versus EPA. The EPA lost a major regulatory case involving the emission of pollutants from smokestacks. Mm-hmm. And the day after the case was decided and the EPA lost, the EPA issued a press release saying, well, sure, we lost the case, but no big deal because the industry has already complied.
Right.
And that was a real shot across the bow of the courts and everybody else, sort of realizing that maybe there should be greater greater restrictions in place on agencies implementing things before the courts have had a chance to sign off. Again, I think it would be a mistake to pass a law saying agencies could never implement things while judicial review is pending, because you might have exigent circumstances in a particular case. But I think it would be good for Congress to sort of flip the presumption. Instead of presuming that an agency's action is enforceable while judicial review is pending and forcing the challengers to prove otherwise, flip the presumption, make the default rule that the agency can't enforce its rule while judicial review is pending unless it can convince the court that it needs an exception in that case. And so I think that's another important reform. And there's a lot of little reforms like this. The House Judiciary Committee has produced just many really good and thoughtful bills on these issues that I think are worth consideration by the full Congress.
Well, the example you gave, it really, if you flip who's in charge of defending their own regulations, you put the onus on the agency as opposed to the regulated party. I mean, it's easy to think of instances where you've got individual business owners who are forced to go to court and forced to comply, spending hundreds of thousands of dollars in some cases on attorney's fees, and then also spending all that money on coming up to the rule. And what's their recourse? Right. I mean, that seems sort of un-American in a lot of ways.
This is a place where I think that reform-minded conservatives could learn a lot from that generation of behavioral economists we heard from for the last decade or so. This is that whole theory of nudge, right? This idea that maybe government should stop short of just telling everybody what to do, but instead create what they call a better decision architecture, sort of a better set of presumptions and default options to just sort of gently nudge people in the right direction. They can still ultimately make their decisions for themselves, but you're going to sort of flip the default switches for some of the things. I think in some ways, reform-minded conservatives should take the same approach, right, as we think about who will nudge the nudgers, right, in terms of thinking about how the administrative agencies work and how they could work better. I think maybe instead of focusing so much on just categorically eliminating some practices or making broad reforms, maybe if we just flip some of these presumptions about enforceability, about what to do with money, about what sorts of processes should happen in the agencies, just change the presumptions and put the burden on the agency to prove that this, or to show that this is an individual case should be done a different way, I think would nudge agencies in the right direction.
Well, that's very good. I thought we'd shift gears a little bit just to talk about what's coming up after the recess is over here. We're here at the end of August. We've got a final week left on the recess. And as I mentioned before, there's very little time left legislatively for the balance of the year. Mm-hmm. Do you have any? Would you like to prognosticate and tell us what you anticipate in this window between now and the end of the year in terms of where you think Congress will head and also the administration's role in all of that?
Well, it's hard for me. I'm not a political expert. I'm still a lawyer, and so I'm probably the last person to ask about these things. But it's we
might as well get you on tape.
That's right. Thanks. You can remind me how I was wrong in 6 months. But looking ahead, it's hard for me to imagine Congress accomplishing much more than healthcare reform, tax reform, and the debt ceiling. If that, right? I mean, that already is a heavy lift, and it would reflect. If they could accomplish those things, it would reflect more accomplishment than we've seen in the first 7 or 8 months of the administration and Congress. And so it's hard for me to imagine any real meaningful progress on the broader regulatory reform issues
right.
Before the end of the year. And then after the end of the year, it's the budget fight starts all over again, and then we head into the election cycle. My hope is that as we get into year 2 and 3, these issues these issues of regulatory reform in the administrative state can get a fuller airing. I mean, really, I think it's too much to ask for them to do it before the spring. But as we get into the spring and summer of next year, I hope that will be their opportunity to do it. But I think it's going to require real involvement by the executive branch. The president, even though he is the executive, his office by design, by constitutional design, is intended to play a real legislative role in terms of proposing legislation for consideration, convening Congress when necessary, and so on. The president is a central legislative actor, and I think he needs to take on that responsibility meaningfully. I think that without real guidance and energy from the president, so many of these things are going to languish. In the context of administrative state reform, I think the key agency is the Department of Justice, which is ironic because, the whole point is that under our current sort of status quo, the Justice Department, on behalf of the agencies, gets enormous advantage through things like Chevron deference and really weak procedural requirements on the agencies. The Justice Department benefits as much as anybody from the things that we're now criticizing. At the same time, that means the Justice Department knows better than anybody exactly how powerful these tools are. And so I think it's unrealistic to ask Attorney General Sessions to tell his lawyers to stay their own hand in litigation, right? The lawyers in the Justice Department need to use all the tools at their disposal, all the legitimate tools at their disposal in existing cases. But the Justice Department leadership is in a position to take a step back and to summarize the current state of affairs, one that Attorney General Sessions knows very well, not just from being Attorney General, but from being a senator and from confronting people like the head of the EPA and other agency officials. And Senator Sessions was very strong in calling for reform when he was a senator. I hope he would take an opportunity in the coming year to use that same energy to inform the legislative process, to have the Justice Department study these issues, issue reports and findings on exactly how bad some of these problems are, and to use that to energize the legislative reform process. And I should add, that's exactly the role that the Justice Department played in the 1930s and 40s when the Roosevelt administration into the Truman administration were first confronting with these things and framing up the modern administrative state. The Justice Department issued a series of seminal reports really investigating and explaining what was being done and what needed to be done to reform the administrative agencies. And I really hope that Attorney General Sessions and other smart and thoughtful people in the Justice Department who have studied these issues for years, people like Rachel Brand, who's been an admirable voice on these issues for years. I really hope that they put their shoulder into this because it's hard for me to imagine legislative success without real involvement by the Justice Department.
Very good. And of course, and then in 2018, we'll have another election and there'll be perhaps a reshuffling of the deck in some ways, and who knows what direction and what effect that may have on these issues for the second half of the administration.
That's very true.
I may be asking you to repeat yourself a little bit, but you recently wrote in a Wall Street Journal piece, titled "The Least Dangerous Branch." You explained that Madison wrote that our government system, the legislative authority, predominates. And you note that the founders were actually most concerned about the dangers of the legislative power. And again, you may have to repeat yourself a little bit, but I was curious, if there's one silver bullet, if there's one thing that we most need from Congress to return itself to its rightful place as the predominant first among equal branch, as we're sitting here today, what is it?
I wish you could ask me an easy question. I'll say that final punchline about how do we make Congress more ambitious.
Right. That's
something that I'm still grappling with because ultimately the only thing that will make Congress more ambitious is an American public that demands and rewards Congress for being more ambitious. I mean, let me just take a step back about that book review. the headline, "The Least Dangerous Branch,"
Right.
is a play on the title of a famous book by Alex Bickel about the courts and the
Sure.
idea that, as Hamilton said in Federalist 78, that the courts would be the least dangerous branch. Right? It's amazing. I think it would amaze the framers, the founders, to discover today that Congress is in many ways the least dangerous branch. The piece in the Journal was a review of a book by Professor Josh Chaffetz of Cornell. He wrote this really great book. I highly recommend it to students of constitutionalism and of Congress. He wrote a book called Congress's Constitution, which was a review of many of Congress's constitutional powers. He focuses less on the legislative power, which people know the most about, and he focuses more on things like the appointments power, Senate confirming presidential appointments or refusing to confirm them. The Congress's power to convene oversight hearings and to hold people in contempt for not participating in them, and on and on. Professor Chaffetz is focusing on Congress's constitutional powers. It's sort of amazing in a way that we even need this kind of a book, right? We need a book to educate the public on what powers Congress has. I think the fact that book exists is a good sign that things have gone dangerously out of whack in terms of Congress receding from the constitutional, the legislative, and governmental scene. And as you said, it cuts against the basic presumptions of the framers in their expectations of what would happen with Congress. Now, what's it going to take for Congress to become more ambitious? Like I said, I'm still grappling with this. In some ways, one of the sort of the conventional wisdom in recent decades has been that the partisan alignment between a president and his fellow party members in Congress, that more than anything else undermined the separation of powers. Republicans in Congress began to think of themselves more as being Republicans than as being in Congress, and same with the Democrats. And so when you have, say, a Democratic president, his fellow Democrats in Congress will align up more with the president's interests than with their own institutional interests, and same with Republicans. If there's one thing we've seen a lot in the last year, but among other things we've seen President Trump's unconventional rise to get to the Republican nomination and then the presidency, I think showing a loosening of the bonds of partisan connection, right? That President Trump is not a conventional Republican. He did not get the nomination through conventional party means, and he sees much less allegiance, I think, to Republicans in Congress. And I think as time progresses, I think we'll see less allegiance from Republicans in Congress to the Republican president. I'm not saying that they'll be more antagonistic. I just think, I hope that they will begin to think of themselves as Republican congressmen and not just Republican congressmen. And if that were to happen, if that were to happen, we might see for the first time at least a trend back towards a more institutionally minded approach in Congress. But I don't want to overstate that, because I think at the end of the day, I think it's inevitable that Republicans in Congress will still be very closely connected to President Trump and vice versa. And so I think this is a generational effort. I'm not sure what all it will entail, and I don't want to hold out too much hope because I have about 2 centuries of experience against me on this. But I remain hopeful.
Well, that's good. That's very good. Before I give you an opportunity to offer any final thoughts for our Article 1 Initiative audience, I just wanted to give a quick plug for our newly announced writing contest. It's open to all eligible individuals under the age of 40, and the topic is Restoring the Constitutional Congress. We're looking for around 30 pages, and the deadline for submission is January 5th, 2018. We have several cash prizes and a top prize of $5,000. To learn more about the contest, please visit fedsoc.org/AI contest. That's fedsoc.org/AI contest. Adam, any thoughts you'd like to leave us with before we conclude?
Well, just one. As I said here in the Federal Society studios, the Federal Society arose at a moment in our history when the Constitution had more or less come to be seen as the wholly owned property of the judicial branch. Constitutionalism was something courts did, not presidents or Congress or states. And I think that was to the detriment of our constitutional system. One of the great victories of the Federalist Society has been to restore a constitutionally minded approach to all three parts of government. All three parts of government and the states and the people all have a duty to take constitutionalism seriously. I hope that we see something equivalent with respect to the administrative state. I'd say in the last 30 years, the administrative state has come to be seen as sort of the main responsibility of the executive branch. And in many ways, rightly so. And I think the emergence of presidential control or oversight of the executive branch was in almost every respect a very good thing. But the cost to that benefit has been that the other parts of government, I think, have lost the ability to think and speak and act sort of forcefully with respect to the administrative state, just in the same way that the presidents and Congresses they lost that ability to talk in constitutional terms. They lost that muscle. The judiciary and Congress, I think, have lost that muscle with respect to the administrative state. And so one of the things I'm optimistic for the Article 1 project and for this entire discussion, just generally the administrative state, is that all three branches of government, I hope, will come to be more directly engaged in the questions and challenges of public administration and not just leave it to the executive branch to solve.
Well, very good. Thank you very much.
Thank
On
you.
behalf of the Federalist Society's Article 1 initiative, Adam, thank you for speaking with us today.
Thank you.
Thank you for listening to Necessary and Proper. If you enjoyed this podcast, please tell a friend, and don't forget to subscribe on iTunes or Google Play. To learn more about the Article 1 initiative, please visit fedsoc.org/Article I. That's fedsoc.org/Article I.
This has been a FedSoc audio production.
if you were explaining the separation of powers to a person for the first time, is there a metaphor or some way of thinking of the concept that you would find particularly helpful? How would you depict it for them?
Well, sometimes, and especially when I'm talking about the administrative state, I like to say, my kids work harder on their homework when they know that they're not going to grade it themselves, right? When they know that there's going to be somebody out there looking over their shoulder and checking what they've done, they'll do their own job better. And so in some ways, checks and balances, when you're thinking about it in terms of an accountability measure, I like to talk about kids not grading their own homework.
Oh, that's great. Do you have a favorite founding father? If so, who and why? Right on the spot.
Yeah, it's arguably Lincoln, actually, which gets to my point about founding and refounding, I guess. But no, in terms of the original generation, no, my favorite founding father is everybody's favorite Broadway star, Alexander Hamilton. He wasn't right about everything, but I think he was right about most things in a very, very insightful way.
And I think I actually already asked him. I was going to say, if you had a magic wand to tackle congressional reform of the administrative state, what would be the number one place you would start? But I think you...
If there's one thing I could change about the discussion about the administrative state, it would be I would urge Congress to think about both the process and the judicial review sides together as a cohesive whole, both the process and the deference, and to think less in terms of just broadly declaring what agencies shall or shall not do, and more in terms of creating an incentive structure to get the agencies to do the right thing.
Very good. Thank you.
Thank you.